to assist the court and trying to urge the court to possibly limit your lordships only to the question that is coming up in consideration.
I told the solicitor also, I'm telling you also. Take it assumed and granted. We will not venture here and there.
I'm deeply grateful because the complexity that I must tell your lordship just one additional point. That after the 2018 amendment to the Prevention of Corruption Act, the entire landscape of the Prevention of Corruption Act was significantly changed. What you will see the kind of changes that have been brought about once again, because exactly what the learned solicitor said is that what the government realized a matter of policy was that many of the provisions were causing lots of policy paralysis and matters were not moving forward. Therefore, there was a select committee that was set up to consider the amendment. Because there was a bill that was proposed in 2013, then ultimately approved in 2018. If your lordship sees the whole approach, legislative approach to dealing with corruption cases also significantly changed. The implications of all that are pretty significant.
We have to deal with
So therefore, I would urge your lordship that I'm only saying
carry forward. It's a little carry forward which has occurred, which is what we have to deal with.
That's the only limited issue I would urge, because the consequences of many of that, particularly some of the issue that the learned additional solicitor raised, I think have some serious ramifications. Maybe in the facts of an individual case, the consequences can be considered, where the stage of consequences also, as the lordship have held, will determine what is the order to be passed. Because sometimes at the initial stage, sometimes at the stage of framing of charge, sometimes after some evidence is led, sometimes at the stage of conviction. There are all these patterns which are there, and where your lordship have held in different ways how it should be dealt with, and discussion is obviously given to the trial court in order to determine whether this provision was mandatory, which reshapes the entire proceeding or not. So those are matters which will have to be considered in the facts of a given case, rather than to lay down some larger principle without assessing. So therefore, coming back to the issue that really troubles your lordship today, just one illustration which is somewhat similar in the realm of criminal law, where what your lordship had occasion to deal with in the context of prospective and retrospective. May I just hand over one judgment? Just give her in that. I'm not going to take your lordship through the series of judgments. Your lordship recollect in Mohanlal, your lordship sitting in 3 judges took a view in a narcotics case that an investigating officer cannot be the complainant, or the complainant cannot be an investigating officer. It vitiates the entire proceeding. And in Mohanlal, your lordships took a view that if the complainant and the investigating officer is one and the same, the entire conviction is vitiated. That was the view that was taken. The question that then came up for consideration was, if this is the law, then what happens to all the other convictions? Because ultimately, your lordship is dealing with fair trial. Fair trial is not just for the accused, but it's also for the state and the victim. So in the context of balancing the principles of fair trial, what happens? So the question that troubled the court subsequently, which was a separate bench, not in reviewing the same matter, separate bench, is what happens if this proposition will overturn convictions which have already been confirmed because of this proposition of law. When that issue came before your lordships a few months after Mohanlal, this is the way your lordship dealt with the matter. And that's why the one issue which my learned friend said is it should be the same bench. Your lordship will see here a separate bench recognizing the problems.
Keep doing every day.
That your lordship does. Therefore, this was the context. Your lordship will just mark the paragraphs, because your lordship will just contextualize it from paragraph 11. The principles and why your lordship should therefore clarify the matter. If your lordship just give me a minute to just read a couple of sentences, the paramount consideration being to interpret the law so that it operates fairly. The facts of that case did not show any need to visualize what all exceptions must be carved out and provided for. The attention of the court was also not invited to the need for considering the carving out of exception. The individual rights of accused are undoubtedly important, but equally important is the societal interest for bringing the offender to book and for system to send the right message. Then para 13. Law has to cater to a wide variety of situations. Law being dynamic, the certainty of the legislation appears rigid. At times, a circumstance.
Mr. Desai.
Wrong judgment. Over the wrong judgment.
What you have handed over is
Mohanlal.
Sorry, the second, I'm so sorry. I didn't want to read Mohanlal because Mohanlal is now being considered prospectively, and that's all I wanted to trouble your lordship with. Please, don't trouble your lordship with Mohanlal. Barinder is the This is where they clarified that it is prospective as a separate bench.
So the only reason you are citing this is to show that the prospectivity is an issue which was decided by a different bench here.
By a different bench, it also, in a sense, sets out the considerations as to when your lordship would need to clarify.
Not a different way, but the case was different. Right?
No, case is different, bench is also different.
Slightly different.
Slightly different.
One judge is changed.
One by three different.
That's right, but you'd say.
Authoring judge will say.
Which are the paragraphs? Just refer to the paragraph.
Paragraph 11,
Yes,
paramount consideration
that you read.
that I read, then para 13, law has to cater to wide variety, law being dynamic, certainty of the legislation appears rigid at time, whenever a circumstance appears which is not catered for explicitly. Expediency then dictates that the higher judiciary, while interpreting the law, considers such exceptions as are called for without disturbing the pith and substance. Because here is the issue of pith and substance that the safeguard was not.
But those are not. What is relevant, I think, is only para 15.
And then para, lordship have had already gone ahead.
15 is the only relevant so far as the aspect you are saying.
On the aspect. That's all.
Okay.
And the consideration. So therefore, all I would say that since this is something, therefore your lordships may therefore look at the narrow issue. If your lordship.
You don't have to, both sides don't have to re-emphasize that. Mr. Datar, what do you have to say?
Very, very brief, just a little. My first submission is going to be with the references in the context of 23, and I'm only requesting my lord that this is a time where we can really look into 20 in bracket 1 once again, which is what Justice Mathur wanted in 2004, and then we were able to persuade the bench. Yes. Now, sorry, your lordship saying.
Procedure and substantive is a different situation.
No, I'm only going to say that 6A should be treated as a substantive.
Import, and clearly in view of constitution benches, we can't import a US point of view to the Indian point of view.
Why?
And then to that extent, solicitor is right, that means you're seeking a reference to a 7 judges bench.
No. What
Obviously, what else is it? There's a view which has been read, which is quite
I
consistent.
just put my point to say, Lord.
Yeah.
The Solicitor General said that the Translation Corporation was in error in referring to US judgments because the earlier judgments in 1950, etc., said that you should not refer to Constitution. Now, my lord, what has happened is this. The question of the US Supreme Court judgments which have said don't refer to Constitution is in the context of interpreting the meaning of the word void. That's what Jagannath says, that judgments of the US Supreme Court, Cooley, Willoughby, etc., in the context of void should not be, and these don't American judgments and American authorities, because what was referred to as being Willoughby.
Constitution is different, the provision is different.
Yes.
We have a different provision.
No, I tell you what, why?
We can't, this will amount to rewriting.
No, I'm not going to belabor on this point. 21 is an ex post facto law. Now, my lord, your lordship sees that 53 judgment which he referred to that 53 Supreme Court.
Shiv Bahadur Singh.
Shiv Bahadur Singh states.
Rao Shiv Bahadur.
Shiv Bahadur Singh, where their lordship says that ex post facto law in England, though it is not there in the written, they don't have a written constitution. Yet they have read ex post facto law into a rule of law principle. That's how England is concerned. Then they say for the first time in the written constitution, ex post facto law was introduced in the American constitution. And Justice Mathur then refers to Calder versus Bull, which has been referred to in a number of cases. That's what he says. He says, how has ex post facto law been interpreted in the US? What are the 4 principles? And those 4 principles, he says, include not only the punishment part of it, but also if there are protections in the context of rules of evidence, they are also entitled to the protection of ex post facto law. Now, I don't see any reason why our Article 20 in bracket 1, which is borrowed from the US Constitution admittedly, cannot also take note. It's not binding, it's only persuasive. It's from point of view, number 1.
To expand like this, knowing our criminal justice system,
Yes.
there are not enough issues already
Yes. No, but not,
in which the system faces, then to now, at this stage at least, traverse a path which even further expounds.
yes. No. I'm only saying that the Supreme Court in Translation Corporation should not be faulted for referring to US Supreme Court judgment because Calder versus Bull has been considered again and again by the court, saying that ex post facto law was first explained in Calder versus Bull and subsequently followed in the context of ex post facto law. What are the dimensions of ex post facto law? It's up to your lordship to say, no, I take a different path. I'm not doing it. But our Supreme Court has said, this is what Calder versus Bull said, we are following it. No, but in many cases, as far as we are, even now we are referring to English cases like Anthony, etc.
I have no hesitation in reference, but I would say reference has to be to context.
Yes.
And we must, when we are dealing with the constitution, we must take note of, there may be principles expounded there, which may be capable of being imported. We are not putting a blank ban.
Yeah, that's what I mean.
We are not putting a blanket ban, but it depends on the wording of the constitution there and this to be able to construe.
That's what summarized. There is no prohibition, there is no allergy to referring to the US or the UK Constitution, the Canadian Constitution. Because, for example, when the revenue bar, the Madras tax, the national taxation value was struck down, they refer to Canadian judgment, they refer to UK judgment, they refer to. So, wherever your lordship wants to interpret, it can be referred.
So, if it gives rise to something which needs to be debated,
Yes.
and there is a view taken even by a foreign court, there is nothing which prevents it to be referred to persuade the court to adopt that course of
As
action.
an aid of interpretation. As an aid of interpretation. That's what I'm saying. Now, my lord, I'm going further. Now, my lord, when solicitor referred to judgments or saying that 21 is absolute ghost, etc. I'm only requesting one caveat or one caution here. All these judgments in the 50s are in the context of the Gopalan doctrine, which said that you take articles in silos, and if a lordship kindly sees, barring further Justice Mukherjee and Justice Vivian Bose, most of it was on a conservative basis, saying that treat the articles in a literal way. That was the general trend. And the dissents of Fazal Ali, Vivian Bose have become the law later. I'm only requesting, my lord, in bank nationalization for the first time, they said don't read articles in silos, articles are interdependent. And your lordship also was a member of the Puttaswamy. Puttaswamy in paragraph 324, 259, this because there's no time, 259 says, we should not focus on the originalistic interpretation of the constitution, but take into account the developments of the law. The lordship has said that don't focus on the originalism. There's also just one point in paragraph 291. Lordship says that all articles are interdependent. And my lord was pleased to hold that Article 14 illuminates Article 21, animates Article 21. I'm only trying to request a lot. If 14 can animate 21, is it not trying to pause and think? Can 21 also animate Article 20, Clause 1? This is what I'm trying to do. This is a new point, not to reject it, but it definitely merits consideration.
You are entitled to expound that proposition.
Exactly. Exactly. I get that. So what I'm submitting is, this is a time where what the Supreme Court in Transaction Corporation says, just not immunity. They said the substantive rights of the accused or the immunity. And if you lordship see the judgment, the referral order in paragraph 6, we took almost an hour to persuade the court not to take a view. First view expressed was, oh, nothing, once the law is declared, it's all gone. It took a lot of effort, that's why they said, finally they were able to persuade us what the court records. We went into all the law and said that, look, this is a time to reconsider the scope of 20, 21, etc. And then the court records that 23 covers 20 bracket 1. Covers substantive rights and immunities. So that's the point. So I only have the solution is, we see this massive judgment where he emphasizes what is the significance of procedure. I think it's a very outstanding judgment which says that procedure is the bastion of personal liberty. And you can't take 20, 21, 22 or the 3 articles dealing with liberty in the Constitution. Part 3, Lordship kindly sees 20, 21, 22 is like a trinity of liberty. So just try to consider that I'm not going to belabor the
we have to also look at, sometimes we forget a victimology principle.
Yes.
There are the victims. Here, in matters of corruption, the state and public society becomes the victim.
I'm not saying no. I'm not saying no.
What I'm saying, take it to such a level.
No,
I not that we should not punish anybody for anything.
I don't say that at all. What I'm not saying is, if legislature has consciously given a substantive right to a civil servant, saying that he will not be prosecuted without a prior approval, if it's a substantive right given, which is in the nature of an immunity, as your lordship put it, the better word is protection. If that protection is given, and lordship is we are not debating societies, we are not doing the general laws, in the context of 6A, in the context of 20 clause 1, in the context of 21, can we not say that 6A was a substantive right, was a protection, was an immunity given to the accused, given to the civil servant in larger public interest, and this public interest has been further interest.
Larger public interest is both ways. Larger public interest
Correct.
and giving them availability to take decisions independently,
Really fair.
but also The fearlessness should not be that fearless, which all of us suffer periodically.
I'm not saying no, but I'm not saying. I'm only saying that what is the concept, what does the Supreme Court say? That if you got a protection, if you got an immunity, will it be a facet of Article 20 in bracket 1? I'm saying it should be a facet of 21 if you are watching to reach the spirit of 21 also and see the whole concept of the Constitution. Can be balanced, that's the point. Then secondly, my learned friend has quoted that one judgment has explained the other. No better example of PMA by being 11 judges, but explained by Inamdar, because of some
Need not
problems created.
labor on that.
Yes, that's one. Then third, last point I wanted to mention was, a lot of reference was made to prospective overruling. I'm only saying prospective overruling doesn't arise in this case because prospective overruling comes when you overrule a judgment. This is a totally different case where the courts confirm 6A. What is the effect of the judgment? And you also said, please don't read Goan Industry and Kailash Sharma and the other line of cases, K. Madhav Reddy, where your lordship is giving enough guidelines. So your lordship said that we know the point, I didn't want to do it. I'm saying that let us not get into prospective overruling and Golapnath and Blackstone. That doesn't arise in this case. So these are my humble submissions. And I would humbly submit that the 17A itself manifests, as put it repeatedly, the intention to continue this immunity, to continue this protection. So if it was an amendment, what should I say? It's a clarificatory amendment because the protection existed before, it existed after, it is after. Therefore, in the hiatus, it has to be read to be continued. That would have been the thing as far as interpretation is. And lastly, I just wanted to repeat, one thought came to be, one test by the court would be, if this was done by the legislature, would it follow the ex post facto principle? That's a hypothetical question you must ask yourself, my humble submission. And our answer will be, if 6A was amended in 2014 retrospectively, I would dare say that your lordship will be pleased to strike it down as being completely arbitrary. Deeply opposed.
Yes, Mr. Kishore.
Only,
No, nothing. No, Mr. Kishore has to argue.
no, only one line. Only one line. Nothing. I'm not argument.
Sometimes I wonder, how does the US court do it? Half an hour each argument, each side has. And a synopsis. We have multiple synopses, 11 volumes of judgments. Let's bring some discipline into our system.
One
Yes, Mr.
judgment
Kishore.
cited is
Thank you.
overruled. That's what I'm saying.
It can't go on a
It
debating
will
point.
take only 10 minutes,
Yes, Mr. Kishore.
Mr. Mehta. Milord, page 33 of my compilation. That will settle many issues.
Okay.
This question of prospectivity, respectivity, retrospectivity or retroactivity rather will go. Page 33 of my main compilation. Para 8. Now, my lord, I have headed it like facts and chronology of the respondent's case do not allow retrospective operations. Can I read it below? Sorry.
Yes.
The fundamental question is,
Just one.
Yeah, page number.
page number 33 of my compilation. Para 8.
Facts and chronology of respondent case.
Can I go read it now?
Yes, yes, go ahead.
Now, the fundamental question is as to which law should be applicable in a case. Obviously, the law existing at the relevant point of time should be applicable. Now, the question is, what is the relevant point of time?
These you had read the dates to show to us the stages at which it had arisen. Mr. Kishore,
It is 33, page number 33.
I said in your opening arguments, you had referred to the stages as the stages of when case is registered.
Right. Yes, my lord.
Words. These dates were read. So there was you were said there were different stages at which time.
Yes, there were different stages.
Yeah.
Stage 1 was, because my question, the question which I am putting to myself is that if a case keeps on pending for 10 years or 20 years or 30 years, and during that period the law keeps on changing, which law shall be applicable to that particular appeal? The case. That question I framed, that I am trying to address with the factual matrix of this case. So this case has certain stages. What was the stage 1? When the case was registered against the respondent. That was stage 1. The stage 2 was when the High Court Honorable High Court delivered the judgment declaring the CBI action as illegal. Section Stage 3 was when the CBI filed the appeal in that judgment in this honorable court. Stage 4 was when the pleadings were complete, when the counter affidavit, etc., were filed and exchanged. And stage 5 was when the matter was being heard finally by this honorable court. Now, during all these stages, the law applicable was Section 6A. Right from the time of initiation of investigation till the time the matter was ripe for final decision, until the time the Union of India had occasion to file a detailed affidavit agreeing with the judgment of the Honorable High Court. That was in 2012, when Section 6A was in existence. Now, during pendency of the case, Section 6A was wiped out. Let us say wiped out, although it was declared as invalid. But let us say it became void. Now, the question is that when a case is pending before this honorable court or any other court, and as in this country, they keep on pending for decades, not for years or months. For example, this case has been pending for last 14 years in this honorable court. Now, during that 14 years or 20 years, law will keep on changing because law is a work in progress, keeps on changing, depending on the socio-economic imperatives and a host of other values and other imperatives. Which law will be applicable to the case? That is a fundamental question. So my humble perception is that the law, either which was there at the time of commencement of lists, or which was at the time of challenging that action in the Honorable High Court and the time of deciding by the High Court that, or when they challenged that judgment in the Supreme Court that, or when the pleadings were complete and the matter was ripe and due for final hearing, that must be applicable. And pendency should not be made as a ground to the change of applicability of the law. And why I say so, now para 10 of my, para 10 on page 36. I have edited law cannot be subordinated to fortuity. Now, the question of applicability of Section 6A judgment is arising only because the appeal filed by the CBI has been pending for a long time. After passing of the impugned judgment of the Honorable High Court, that was on 5/10/2006, retrospective application of the Subramaniam Swami's 6 May judgment, 6 May 2014 judgment, in the respondent's case means that it is the pendency of the case which will determine as to which law should be applicable to a particular case. When a particular case will be finally decided is a fortuitous circumstance. Some cases are decided early, some cases get delayed. Had the appeal been decided earlier, when it was ripe and due for decision, that is in 2007, the question of applicability of Subramaniam Swami's judgment would not have arisen. Applying 6 May 2000 judgment to the respondent case means that judicial decisions are being subject to 40.
The law will apply. You can't say because my matter is pending, even if the law is changed, chain law will not apply. Of course, what principle of law will apply is different. How can you? Judgment will just change. There is a question. Yes. Anything else?
Now that is one point.
Yes.
Another profound point which the learned ASG has raised, that if there is a statutory requirement in the law contemplating some kind of section or approval, prior approval or permission, and if it is not taken, then the proceedings are valid and the accused has to prove that some real prejudice has been caused to him. If actually the prejudice has been caused, then only that act of not taking sanction approval shall be taken into consideration. So on that, I have quoted about in my compilation 7 pronouncements right from the time of Privy Council. The first judgment is 1948 in Dwarka Das Moratha versus the king, where they said that in the criminal law, when a mandatory procedure is prescribed in the law, the investigating agency or prosecuting agency do not have a discretion or choice. They have to comply with it meticulously. And if they don't, then it amounts to prejudice per se. And they have not only quashed the proceeding, even the convictions have been quashed. I have got 6 judgments from this honorable court, including one from the Privy Council. And when all these things happen, that otherwise what will happen? An investigating agency or prosecuting agency has been mandated by law to follow a certain procedure. They may follow it, they may not follow it. And then the burden is cast on the accused that to prove that the prejudice has been caused. So the law will be reduced to a nullity because they will not follow it. And this question came in the Vineet Narayan's case, and I'll read what the Vineet Narayan has said. Now this is 1988 SCC 889.
See, you said 10 minutes, we have got 2 minutes, you may conclude. If you start reading, it will not finish. We spent 6 hours on this matter.
This is last.
Small time.
This is my last sentence.
Okay.
Just kindly read what the Vineet Narayan has said.
Yes, read.
On page 918 of the judgment.
Read out, read out.
Para 29, my lord.
Yes.
The duty, I'm reading on page 909, para 29.
Yeah.
The duty of the court is that such proceeding is therefore to ensure that the CBI and other government agencies do their duty and do so strictly in conformity with laws. In these proceedings, the court is not required to go into the merits of the accusation or even to express any opinion thereon, which is a matter for the consideration of the competent court, in which it is therefore necessary that not even an observation is made. That is reading it.
Thank you.
There has to be meticulous compliance with law.
Concluded then.
Any violation constitutes prejudice.
We are grateful to your lordship.
Thank you. Grateful.